And the Supreme Court today began hearing petitions challenging the election of President Uhuru Kenyatta in the October 26th repeat presidential election. Now, the IEBC defended its decision not to conduct nomination of candidates ahead of the repeat polls, saying it wasn't catered for in the law. Now, a petition by former Member of Parliament Harun Mwau, an activist in John Jomue, and Khalif Khalifa, who argue that the IEBC failed to conduct fresh nominations of candidates and fresh elections in accordance with the law. Earlier in the day, the Supreme Court ordered the IEBC to avail Forms 34A, 34B, 34C and a certified copy of the voters' register to the petitioners for scrutiny. And of course, that story, I've seen a political reporter still working on it, but still on the same story, the opposition leader, Raila Odinga, will have to follow the two presidential election petitions challenging President Kenyatta's re-election from the periphery after the Supreme Court kicked the opposition coalition out of the filed suits. Tonight, Murimi Mwangi highlights NASA's options outside the court as the hearing continues.
No reform, no elections. No reform, no elections.
It was the National Super Alliance rallying call that saw 27 constituencies miss out of the October 26th repeat presidential poll, in line with opposition leader Raila Odinga's withdrawal from the ballot. And now, the Chief Justice David Maraga-chaired six-judge Supreme Court bench has kicked Odinga's coalition out of two election petitions, challenging President Uhuru Kenyatta's re-election. This at the invitation of Kenyatta's legal team, which questioned the logic of NASA's input in suits emanating from an election it boycotted.
What I felt listening to the NASA lawyers argue, they were actually introducing an entire petition outside the constitutional timeline of within 7 days. So I do not think that the judges will have actually allowed that.
It was not our primary obligation or even a secondary obligation to support the claims made by the petitioner. Because if you look at it from the foundation of the petition and the evidence put forth, the petition seems to be well grounded.
Odinga arrives back in Kenya on Friday to resume his coalition's push for electoral and constitutional reforms, a strategy tied to ongoing debate and adoption of People's Assembly's bills in NASA-controlled counties and the secession debate within the opposition. Odinga's handlers dismissing as inconsequential a likely swearing-in of President Kenyatta for a second term, in the event that the top court upholds his controversial win.
You remember President Mwai Kibaki was sworn in way past 5 o'clock in 2007. But that did not stop the political processes that were going on after that.
In 2007 and 2008, the old constitution provided that scenario. And that is why we formed the provisions of the National Accord, which was only for that particular period.
But as the top court struck out NASA from the petition, the bench also expunged all internal memos leaked from electoral body IEBC, and which had been filed as evidence by petitioners activists Khalif Khalifa and John Jomue. A verdict which some experts argue could be a blow to key elements grounding the petition.
The court could have intended to preserve the integrity of organizations that act in a manner that requires that decisions be taken through consultation. Because when this information is out before a final agreement has been made, then it can jeopardize the decision-making process of that organization.
The spotlight now turns to key arguments against Kenyatta's election, including the legality of the repeat poll after Odinga's withdrawal, and a query raised by former Kilome MP Harun Mwau against IEBC's failure to freshly nominate candidates before the repeat poll. Now, even with their push for a political solution to the prevailing stalemate, NASA will have to watch the Supreme Court petition from the periphery as the countdown to the Monday deadline for a final verdict continues. Murimi Mwangi, KTN News in Nairobi.